For years in Kenya, teenagers could face long prison sentences for consensual relationships with other minors. But now, that colonial-era system has been challenged in a landmark court ruling, reshaping Africa's legal systems around teenage relationships. Now, Kenya's High Court has ruled that the state cannot automatically treat consensual relationships between teenagers as criminal offences. But the court was also clear about something important. This does not legalise adult relationships with minors. Instead, the judgment says that police and courts must distinguish between sexual abuse cases and consensual relationships between teenagers who are close in age. The case was brought by rights groups in Kenya. They argued that Kenya's sexual offences law was too broad and was treating ordinary teenage relationships the same way it treats predatory abuse.
The High Court of Kenya has issued a landmark decision finding that the blanket application of provisions of the Sexual Offences Act expose adolescents to criminal prosecution for consensual, non-coercive, non-exploitative peer relationships, violate their rights.
The case gained national attention after a series of high-profile incidents. In one case earlier this year, a 17-year-old boy was charged with defilement after police found him with his 16-year-old girlfriend. Now, another case involved a teenage pregnancy that later triggered criminal charges before those charges were eventually dropped. Now, rights groups say that the law created fear across Kenya's youth population. Under the previous system, consensual sex between teenagers could lead to a 15-year prison sentence. Critics said the law was punishing teenagers rather than focusing mainly on real abuse cases.
We have had young boys and in few cases young girls charged with defilement for engaging in what has purely been a peer, consensual, non-coercive, non-exploitative sexual relationship.
The ruling is also being seen as a major public health decision because, according to rights groups and health experts, criminalizing teenage relationships did not stop them. It simply pushed them underground. Now, health data shows that around 15% of girls between 15 and 19 years of age in Kenya have experienced pregnancy. In some poor urban areas, that number goes even higher. But many teenagers were afraid to seek medical help because pregnancy itself could trigger a police investigation. Rights groups say that this fear kept many young people away from clinics, sexual health services, and counseling. And analysts say it also contributed to dangerously high levels of unsafe abortions and untreated sexual health issues. The ruling could now have effects far beyond Kenya. Many African countries still use sexual offence laws rooted in older legal systems, which often do not clearly separate abuse cases from consensual relationships between teenagers. Analysts say the decision could influence future court challenges across East and Southern Africa. But the decision is also likely to face strong pushback. Kenya is a largely Christian conservative country, where sex education and contraception are still highly sensitive topics in many communities. Some critics fear the ruling could create confusion around enforcement, particularly in a country still dealing with high levels of sexual violence and gender-based abuse. The court, however, repeatedly stressed that the ruling applies only to consensual relationships between adolescents who are close in age. Adult relationships with minors remain illegal. For now, the High Court ruling remains active unless the Kenyan government decides to appeal. What this case ultimately exposes is a much larger debate now emerging across many African societies. A debate about how far the state should go in policing private life and whether old morality laws still match the realities of today's Africa.